I am hearing now the court hearing for what should be, I'm going to just bring this out, for what should be the ruling in Tamara Lich. Bail breach, alleged bail breach. Okay, I'll do all the standard disclaimers afterwards. The hearing is live now in my ear. Cannot rebroadcast any video, audio of this hearing. This hearing is the reading of the judgment as to whether or not Tamara Lich is going to go back to jail, or sorry, has breached the terms of her bail. There is echo. I know there's going to be echo. I can't do anything about it. Mic check. Is it better if I really get up and eat the mic? Is it better like this? I can't do anything about the echo because there's nothing in this room. Reverb. Okay. So maybe if I talk like this, is this better? Is this better? Tamara Lich, the judge is reading the ruling. For anybody who doesn't know, she was arrested and detained for now 10 days for an alleged breach of her bail release, which consisted of taking a photograph with an individual that she was not supposed to interact directly or indirectly with on release. I'm nervous. I actually am nervous like I was the last time. So I'm going to eat the mic. I'm going to eat this mic. If it's better, seriously, if it's better when I push my face into it. Okay, the judge is warning the courtroom now to maintain decorum, or they could face contempt. The judge is reading his decision on the hearing, which was pleaded on Tuesday. The judge is summarizing the procedure. They've made the request to have Tamara Lich present today, and she is present in person. The Crown has petitioned the court to cancel all previous releases. I'm live streaming on Rumble right now. I'll get to the standard disclaimer super chats afterwards. The judge is asking the clerk to read the charges. Asking the clerk to read all of the charges. And by the way, I'm going to get panels for this room, sound panels, because it's an empty information 22-R1, the charges against her. She's charged on the first day of December 2021, February 28. Indictable offense of mischief. Advising one or more persons contrary to the section of the criminal code. Mischief. Further charged, first day of December and February whatever. City of Ottawa. Counsel to commit the indictable offense of intimidation. Section 464A Criminal Code. Further charged. These are the underlying charges. Not an ad. Obstructing police is her third indictable offense. By the way, these could also be summary conviction, which would be a lesser offense. Nope, they went with indictment. January 2022 and February in the city of Ottawa, willfully obstruct a police officer in the execution of his duty. Okay. Obstructing an officer. I think that's perjury-ish during the bail hearing. They're in 2022 now. These were the additional charges. Wrongfully without lawfully authority. Caused one or more persons from abstaining from doing what they were lawfully obliged or authorized to do. Block or obstruct. Block or obstruct. One or more. Oh, God, did you say highways? I think she said highways. January 2022 and February 2022 in the city of Ottawa, East Region. Mischief. Section, whatever, in the criminal code. Mischief. Counseling to obstruct. Okay, so those are the underlying charges. And now we're getting to the new charges. It would be a joke if it were funny. It's terrible. They're reading the newer, non-trumped up charges. Being at large on a release order. Fail without lawful excuse to comply with that release order. Meaning, to not contact or communicate directly or indirectly, physical or other means with the following people, one of whom is Tom Marazzo. I'm not going to name the names because I don't know if there's a publication ban on any of the names. I don't think there is, but one of them is Tom Marazzo. That's the one that's clearly not subject. Got a pain in my stomach, actually, like a physical pain in my stomach right now. Tom Marazzo, the clerk said Tom Mazzaro. Except through counsel. Can't contact directly or indirectly. Tom Marazzo, except through counsel. But I'm not sure if it said except through counsel or except in the presence of counsel. I'm going to see if they correct that. Where's there no sound? You're not hearing any of this because you're not. I can't rebroadcast any portion of this. Yeah, the echo. I can't do anything about the echo for the time being. I can do MSR if I have the mic directly like this. Oh yeah, Viva ASMR and a little bit of what's the word I'm looking for? Radio voice. We can hear you. Good. Mic closer, door open. You don't want me to open that door. Sorry. So I've got in my left ear the Zoom meeting. Judge is reading it. Clears his throat. He says the judge says before we go further, there's 2 limited publication bans. He's going to mention the sections of the code. Okay, there's some publication bans which I'm not even going to walk the line in mentioning what the bans are, but okay, so there's certain apps publication ban on the CERTI and another individual involved. Ban on the identity of the CERTI and Ms. Lich's daughter. So, everyone out there, err on the side of caution. 20 exhibits the judge is referring to. TikTok videos. Crown provided 20 additional exhibits. Defense provided the court with CERTI affidavits. Okay, his judge says, as noted in exhibit number 8. I'll just do this here. Okay. I'm going to fix the angle too, eventually. This is all temporarily set up. I got a vent, breathing cold air on my back. So I'm going to fix all this up. At least I've got high-speed fiber optic internet. Booyah. So the judge is going to get it right. I can feel it in my palms because they're cold but not wet. Okay, so the judge is going to start reading the judgment soon. Karimji's in the house. What did I just do here? And I've said this and I'll say it again. Karimji deserves sua sponte court sanctions. Karimji, I know people are saying nowhere close to malicious prosecution. I disagree. Malicious prosecution is something so out of the norm, so disproportionate. Okay, judge is reading. Section 524, subsection 3. Okay, the judge is reading. Okay, he's reading a link of sorts. There's a lot of slashes. Oh, section. Okay, he's reading the sections of the criminal code. Yeah, there you go. That's it. Thank you. So now the judge is summarizing. He's reading the law. They can cancel her release if they find that she's breached the terms of her release, bail. If there are reasonable grounds to conclude that she's committed an indictable offense related. That being said, as noted, exhibit number 18. He says that there's proof enough that an offense has been committed. Oh, okay. I thought he just said that it was granted as per the request of the Crown. It wasn't. Okay, so he's just setting the positions of the parties. I thought he just said that he was granting it as per what the Crown requested, and my stomach fell. Summarizing who Tamara Lich is, he says, positive note, you don't have a criminal record. You're a mother, grandmother. He says there were some previous decisions made by other justices. He said she's appeared before 3 different judges. You'd think she committed murder. Yeah, it's. She was detained by Justice Bourgeois, which means a bourgeois. Released on a surety. The judge has not ruled yet. Holy cows, did I misunderstand for a second? Okay. Now he's going over the Johnston order, which was the release of Tamara Lich, which said Judge Johnson was impressed by the new surety, wasn't convinced she was, reasonably going to spend that much time in jail, if I'm understanding correctly. I can't. So now he's talking about the bail review in front of Justice Phillips, and that was when the Crown moved to have her locked up again. Okay, so Justice Phillips was another judge, de novo assessment from scratch. Phillips let her out, said there was no substantial likelihood of recommission, and to ensure the public's ensured confidence in the judicial system, Phillips released. He released Leach on the same terms as the previous release, which was Justice Johnson. Okay. The judges The judge is commending the 3 previous hard decisions of the previous justices. He's got to be flattering to those he's going to disagree with. So I think this is going well. 4th time, he says, that Lich is appearing before the court. Why are we here, he says, again. That's the question we're asking. Before he answers it, he's going back to the decision. Before we answer that, he's going to go back to Justice Phillips' decision, justifying her release. It says, it was intended to ensure people would not lose faith in the justice system and that it was proportionate. And he's saying basically the previous judge released her, said she should go. But it reiterated the previous judge's terms. And now he's saying, but it included the provision not to communicate directly or indirectly with a number of people. Number of names, more names. And Tom Morazzo, they can't get his name right. Except through counsel or in the presence of counsel, the judge just said. And that was what I pulled out, noted on when the clerk was saying it, because the clerk did not say or in the presence of counsel, and I thought that was one of the terms. The Crown is alleging, and he's quoting directly from the Crown's position, directly. On June 16, 2022, Tamara Lich attended Toronto to go to the JCCF George Jonas Award. During this gala, Lich can be observed sitting at a table with Tom Morazzo. She received the award, returned to the table. It's observed that she interacted with Tom Morazzo. It was captured on video and posted on Facebook. Furthermore, throughout the evening, they posed for a photograph. And it was posted on Facebook. Okay, the judge invites all interested parties to read it. Says, in addition to the charge, the Crown also submits that new information should be considered. Okay, new information. Winston is nervous because he farted. Okay, so new information. Oh, that's right. The text messages between Tamara and another individual where they talk about a plan to gridlock the nation's capital. And apparently these text messages are old text messages. The judge said, now the Crown has chosen to proceed by indictment. No. Now they're saying, now the judge is basically saying the defense now has the reverse onus to show why she should not be locked up, which is a reversal of the principle of criminal justice. In short, Ms. Lich must prove to the court why she should be released yet again. This is a bail hearing and not a trial, the judge says. He's not here to judge the alleged breach or determine if further charges are warranted. He says, I am here to determine that Ms. Lich can be released. This court recognizes the Canadian Charter of Rights and Freedoms. She's presumed to be innocent and can be released if the court determines the person is releasable. So they're talking about the terms of release. The plan of release is basically reiterating the old plan. I just put it back on slow mode, people. Sorry. Keep the peace, 5,000 bond, reside at her address in Alberta, not contact directly or indirectly in the absence of counsel with the other parties. And they're naming the names. So basically what he's summarizing the defense position, release her again under the same terms, because she didn't breach them, by the way. That's going to be the bottom line. Malicious prosecution by the Crown is what this is. She's not allowed posting on social media. Okay, they're just going over the terms of the last release. Social media ban, not to allow anyone else to post messages on social media on her behalf, yada, yada, yada. And she can't express approval for future protests. Can't organize public protest or demonstration or lawful assembly. She can't participate in any public protest in respect to anything related to the COVID-19 pandemic. The Freedom Convoy. Yeah. And then the final condition, not to attend the limited area in Ottawa. How ridiculous is this? It's fucking ridiculous. It's ridiculous. It's ridiculous. So he just summarized the plan put forward. He says there is a surety that has been proposed. He's identifying two areas of concern with the surety. He doesn't find it troubling enough to warrant disqualification of the surety. So he's talking about the manner in which the surety put up the amount of money. Okay, so it's a non-issue, but the surety said, I put up a non-refundable deposit as the surety. And they asked, and she said, I did that. The surety said, I did that with an RSP or whatever funds. And the court examining her said, well, how did you do that if it's with retirement funds or whatever? And the surety then acknowledged the monies came from different places, and I think from her parents. Just a question of how she came up with the money. Now the judge just asked if the surety is online, and they said yes. If this is malicious prosecution, can she sue? She can, but we'll see. It would help, in my mind, if the Crown gets reprimanded by the judge, if only verbally. Secondary grounds of release. Is there a substantial likelihood that she'll commit a criminal offense or interfere with the administration of justice if released? Secondary ground justifies continued detention, according to the Crown. Okay, they're talking about likelihood of reoffending. So they're discussing whether or not she would be a risk if released. And if they determine that she might be a risk, then she must convince the court that if released, she won't be participating in unlawful activity. I don't. Okay. Okay, the judge is going over the law. In reviewing the secondary grounds, many conditions are considered, many factors considered, such as accused criminal record, non-compliance with previous orders, which is good for Tamara. The nature of the offense, good for Tamara. The stability of the accused, good for Tamara. And also the plan of release, good for Tamara. She's going to get a good decision today after 10 days in jail, is the way I'm seeing this. The judge says detention may be ordered if it is required to retain confidence in the judicial system. Having regard to all circumstances, including the strength of the Crown's position. Circumstances surrounding the offense, whether or not a firearm was used, etc., etc. Okay, they're talking about if there is a firearm involved. What if an independent reporter interviews her? Is that not allowed? They can legally stop the press. They can legally prevent her from giving an interview. They couldn't stop someone from interviewing her, but they could stop her from answering, from being able to speak. It's a gag order. Okay, they got the tertiary ground analysis. Now the judge has said, he says, let's set the scene here with the facts. I'm so neurotic that somehow the audio is going to be able to be heard somehow. The new evidence is Exhibit 17. And I'm not sure, the text messages. The new evidence is old evidence, by the way. Yeah. Someone's phone just went off, and it's not mine. I'm not there. Okay. New evidence, Exhibit 17, old text messages, I think. He's reading the text message between Lich. He's saying Lich, by the way, so. The text message says they have a strategy to gridlock the city. This is obviously old. Then Lich says, okay. That's part of the new evidence, but it's old evidence. And then now he's getting to the alleged breach, which is the 5-second video at the JCCF award, George Jonas Award. Maxime Bernier, he says it includes notable personalities. Maxime Bernier, his wife, Rex Murphy at the table with Tamara Lich. Sweat Melissa, this is even justice is still going to be an injustice now. Thank you, Modema. He says no other people at the table have been identified as legal counsel, or should I say more specifically, legal counsel for Ms. Lich. He says she received the award undoubtedly in support of her actions during the protest. She proceeds to give a short acceptance speech. Round of applause. Then she returns to her seat. She passes by Marazzo, touching him on the back, then whispers something in his ear. That exchange lasts less than 3 seconds, and I think I heard an emphasis. Now they're talking about the photograph. So I think the judge just emphasized less than 3 seconds. I hope that I'm not hearing things. He says there's a photograph. None of them in the photograph are identified as legal counsel. And I don't like that. I don't like that, but in applying the 4 essential elements, tertiary grounds, so you look at the strength of the case in relation to the substantive charge, refers to the text about gridlocking the nation's capital. And then he goes to so you have the underlying mischief offense, the text message, and the breach, the image, and the video. He says, no direct testimony has been provided to confirm the presence of counsel. He says, I believe the Crown has a strong case to prove the alleged breach, although the presence of counsel could be a defense. I don't like the way this is going. He says, it's the Crown's position that the severity of the breach could result in 10 years in prison. He says, no firearm was used in the offense, yada, yada, yada. All of a sudden, it doesn't sound so good. In the case of the breach, she's alleged to have communicated and touched Marazzo. Tamara in the text message said, they have a strategy to gridlock the city, and I do not want to make those decisions on my own. But that's old evidence. He's saying no firearm was used. But the Crown has indicated the potential for a sentence of greater than 3 years for what Tamara did. She's alleged to have flaunted her opportunity to receive the award. Furthermore, Ms. Lich chose to sit at a table with a gentleman that she's not supposed to have contact with. The Crown has asked the question, how can the public have any confidence in the administration of justice when Ms. Lich, he says it this way, Lich, flaunts the terms of her release, which she was ordered not to do? The Crown argues that her inculpatory statement that she doesn't want to make that decision should result in her being locked up and detained. These are his concluding statements. He's summarizing the defense. They vigorously defended their client. Okay, about the text messages. It says the text messages attributed to Ms. Lich are not conclusive. He's citing the defense's position. And Tamara Lich was in the presence of counsel when she interacted with Marazzo. And now the defense also says it was a minimal, if any. Minimal breach, if any. 3 seconds. De minimis. Says, so this says de minimis, the idea is it's de minimis copyright violation as well. If you used so little, it's irrelevant. If it's such a minimal breach, the law is not interested. Stealing a penny from someone, unless it's a 1936 penny with a dot underneath, irrelevant. And they're saying it's such a meaningless, insignificant breach, even if it's a breach, that even if it is a breach, it should be considered serious enough to warrant anything. And now the court says, though, we only saw one-way communication of what Lich said to Marazzo. He says, in the absence, with respect to the mens rea argument, the court finds it to be a faulty argument. She chose to sit at the table. The court also finds that there was no presence of counsel and that there was no counsel in the photo. The court, with respect to the text messages, the court says she was a decision maker. The actions are troubling in the face of the events of February of 2021. The communications indicate that she might have been a leader of some sorts, and to be determined how critical a role she played. I hope this is clear enough, people. The judge said, with respect to the absence of mens rea argument from the defense, they're not convinced. The court just took judicial notice of the chaos caused by the protest last February. The city was forced to expend great sums of money and resources. And the city gridlock, I mean, I don't think the judge was there if he refers to city gridlock. He says Ms. Lich will have to answer at some point for her involvement. And now he says, with respect to the release, it is a reversal of the onus situation. Tamara does have to prove that there is no substantial likelihood that she'll reoffend. Although dated, the new evidence indicates Tamara's involvement as a decision maker. Although dated, although it's old, although the protest has now ended, freedom protests continue. And I'm sure throughout other cities in Canada and the world, Judge, and the world. So she continues to pose a risk, according to the judge. He says she was given permission to attend the awards show. He says it stands to reason that the permission given did not authorize her to sit at the table of Marazzo. It didn't envision that. Such actions must certainly erode the public's confidence in the administration of justice. He says her attendance, this court finds her attendance problematic. The vulnerable victims of the Freedom Convoy will undoubtedly continue to fear a reoccurrence of the protest if persons such as Tamara and Marazzo are continued to allowed to socialize in whatever way they want. The court concludes that she has not met her onus on secondary grounds and finds in favor of the Crown's arguments. This court has been provided with concrete evidence of her decision making and her decision to gridlock the Capitol. And there's evidence of the breach of the non-contact. The evidence presents for a strong Crown case. Now the judge, he's going to address the de minimis. De minimis should not even be before the courts. It's this court's belief that although the contact in the video short and passing, one cannot overlook the overall impact of her attending the gala. The gravity of the seriousness of the breach is evidenced by her actions and shows that she's not prepared to abide by court orders and do whatever she's prepared to do whatever she wants, including choosing not to adhere to the no contact reiterated by Justice Phillips. I can't believe this. I can't believe this. Now he's talking about whether or not she's susceptible to a lengthy prison term. There's no firearm. We've heard that, Judge. However, from a circumstantial standpoint, Ms. Lich was allowed to attend the awards show with the expectation that she would abide by the terms of release. We now have video photograph evidence that she did not. The potential, and he stresses the word potential, for a lengthy term has been identified by the Crown to be around the 10-year mark. Mischief. He says he finds it cumulatively, she's not met her onus. Cumulatively, she has not met her onus. Oh, he says that she was allowed to attend this awards ceremony to celebrate her actions for an event that placed the citizens of Ottawa in a continued state of fear. After giving a short speech, Ms. Lich then chooses to communicate with Moretto. Then, to add even more fuel to the fire, this is what the judge just said, she chooses to pose with a photo. From the perspective of a common person, one would find this puzzling in light of the existing non-contact provision of her bail release. Ms. Lich has chosen to exercise her freedom by not respecting the no contact. And she did it in such a fashion to flaunt her actions with the misguided excuse of having counsel present. Holy shizzle. The non-contact, he's suggesting why it exists. It's to prevent co-accused from communicating, except, he says, it's absolutely ridiculous. He says it's absolutely ridiculous to think that the no contact rule of the release could be superseded by presence of counsel. He says, your detention is necessary to retain confidence in the system. They're detaining her. She's staying in jail until the hearing on the merits. She will be remanded back into custody. This is Well, there won't be sanctions against Moise Karimji. You won't sanction the winning party for malicious prosecution. There will never be malicious prosecution. Any chance that Tamara ever had for malicious prosecution has been eviscerated by this court ruling. And this is beyond, this is outrageous. Miscarriage. I did not expect it. I'm at a loss for words. It's beyond shocking. Canada has become a North Korean style dictatorship. This should be on Fox News. This should be on Tucker Carlson. They are continuing to detain Tamara Lich because of the photograph and the the judge is now addressing her. You haven't met your onus. You'll be returning to court on the 14th of July. Judge is asking that the court be cleared. I'll talk about this afterwards in a second. They're going back to the normal docket. No, the judge wanted to have her there in person so he could say it to her face. The judge, by the way, because she wasn't allowed in to court the other day because she refused to submit to a COVID test, the judge made sure that she was there today in person, not to release her, to send her back to jail. Now there's some leftover. I'm just going to hear what's going on just in case. Now they're laughing. Now everybody's having a yucky time. Yucking it up. Yuck it up, fuzzballs.